Greetings and welcome to Lavo and Maxim Foundation, a university of freedom and free thoughts. In this webinar, we're going to discuss the private security agreement, the commercial security agreement, hold harmless indemnity agreement. This will conclude the first section of the agreements that need to be filled out when making the transition and your status correction. So to start off, we're going to start off with the definition. So this definition comes from Wikipedia. What is a security agreement? A security agreement refers to a document that provides a lender a security interest in a specified asset or property that is pledged as collateral. Terms and conditions are determined at the time the security agreement is drafted. Security agreements are a necessary part of the business world, as lenders would never extend credit to certain companies without them. In the event that the borrower defaults, the pledged collateral can be seized by the lender and sold. Key takeaways from Wikipedia are: a security agreement is a document that provides a lender a security interest in a specified asset or property that is pledged as collateral. Security agreement often contains covenants that outline provisions for the advancement of funds, a repayment schedule, or insurance requirements. These agreements may also pertain to intangible property such as patents or receivables. So let's think about this for a second, tribe. Now, a UCC financial statement is a security agreement. It's a security interest, right? Where the collateral is pledged from the debtor to the secure party, right? Now, with that, you need to have a security agreement uploaded to that UCC. This is how you take your debtor, the initial steps of taking your debtor and extending credit onto it. So let's say Jane Henrietta Doe has an asset and it conveyed it to Jane-Henrietta Doe L for a term of 6 months, and the debtor is supposed to pay the creditor these terms of this security agreement. And that is how originally you can start doing trade lines and building the credit of the creditor by also conveying the assets over to the creditor as well. So that is where a security agreement comes into play. Now, let's go over to Wikipedia to read a little bit more about the security agreement. Okay, so here we are on Wikipedia security agreement. For agreements pertaining to the national security of participating states, see treaty. All right, so this takes us into another layer of understanding what a security agreement is. When you are getting into doing your nationality and doing your tribal affiliations, then you now know that a security agreement is also a treaty. Okay, there is no such thing as a nation without a treasury, without a species. So when you're engaging and you're becoming an affiliate after your nationality, I do hope that you guys are taking my advice on getting your estates and on the record before you are entertaining being a party to any type of affiliation, okay? Because you want to come in that door as a creditor, and you want to come in that door with your security agreement so that you have vested interest in your actual nation itself. So that is something for you to go and to research on your own, but I'm going to kind of feed into it for you here. A security agreement in the law of the United States is a contract that governs the relationship between the parties to a kind of financial transaction known as a secured transaction. Secure transaction. So back to the UCC Article 9, titled Secured Transactions, okay? In a secured transaction, the grantor, typically a borrower, but possibly a guarantor or surety, assigns grants and pledges to the grantee, typically the lender, a security interest in personal property, which is referred to as the collateral. Examples of typical collateral are shares of stock, livestock, and vehicles. A security agreement is not used to transfer any interest in real property, land, and real estate, only personal property. The document used by lenders to obtain a lien on real property is a mortgage or deed of trust. The security agreement sets out the various rights the grantee will have with respect to the collateral, which are in addition to all other rights which the lender may have by law, such as those rights contained in Article 9 of the Uniform Commercial Code, which has been adopted in some form by each state in the United States. Make sure, guys, make sure that you are looking at your state constitution, that you're looking at your state code, okay? Everything has been codified. And I'll go a little bit into that after this read. The security agreement also addresses issues such as permitted sales or other transactions with the collateral in the ordinary course of the grantor's business, and notices that may be required to be given by the grantee to the grantor if certain actions are taken. There are many forms available for purchase from legal supply and banker supply companies, where in addition to software that will produce a security agreement according to specific user input. A security agreement may be oral if the secure party, the lender, has actual physical possession of the collateral, where the collateral remains in the physical custody, where the collateral remains in the physical possession of the borrower, or where the collateral is intangible, such as a patent, accounts receivable, or a promissory note, intellectual property. The security agreement must be in writing in order to satisfy the statute of frauds. The security agreement must be authenticated by the debtor, meaning that it must either bear the debtor's signature or it must be electronically marked. It must contain a reasonable description of the collateral and must use words showing an intent to create a security interest. The right to seek repayment of a loan by foreclosing on the collateral. In order for the security agreement to be valid, the borrower must usually have rights in the collateral at the time the agreement is executed. If the borrower pledges as collateral a car owned by a neighbor, and the neighbor does not know of and endorse this pledge, then the security agreement is ineffective. However, a security agreement may specify that it includes after acquired property. If such a specification is included, then a pledge of all automobiles owned by the borrower, which include the neighbor's car if the borrower were to buy that car from the neighbor. In order for a security interest to attach to the collateral in the possession of subsequent purchasers, it must be perfected. Beautiful word. I love perfect presentation. But we'll get to that after I finish. If the security agreement is for a purchase money security interest in consumer goods, perfection is automatic. Otherwise, the lender must record either the agreement itself or a UCC-1 financing statement in an appropriate public venue, usually the state secretary of state or a state business commission under that person's authority. Perfecting the interest creates constructive notice, which is deemed legally sufficient to inform the rest of the world of the lender's rights in the collateral. Where a borrower has used the same property as collateral with respect to multiple security agreements made with different lenders. The first lender to record that the interest has the strongest claim to the property. First in line, first in time. Okay, right there we knew the specifics on how to legitimize our security agreement. So this is where the commercial security agreement comes into play, because the commercial security agreement is an abstract of the complete private security agreement. So you did put it on the record, the commercial security agreement, along with that UCC-1 regional filing as an attachment, okay? The private security agreement remains private. Now, you will be adding on to your collateral, hopefully, if you do maintain this lifestyle, so it will continue to grow. But I do want you guys to really get an understanding, if you're not inside of the mentorship, that you kind of have to self-navigate. I want you to really get into that UCC Article 9, okay, because this is pertaining to commercial contracts, all right? Now, the law in the United States, so we could break down this codified section of it. All right, so I find it funny that the title of this is called The Law of the United States. Now look at the word "the." All right, this is where we want to be with the people, right? So, the law of the United States comprises many levels of codified and uncodified forms of law. the supreme of which is the United States Constitution, the foundation of the federal government of the United States. Are we paying attention? The Constitution sets out the boundaries of federal law, which consist of acts of Congress, treaties by the Senate, regulation promulgated by the executive branch, and case law originating from the federal judiciary. The United States Code is the official compilation and codification of general and permanent federal statutory law. Federal law and treaties, so long as they are in accordance with the Constitution, preempt conflicting state and territorial laws in the 50 U.S. states. Pay attention. And territories. However, the scope of federal preemption is limited because the scope of federal power is not universal. In the dual sovereign system of American federalism, because of the presence of Indian reservations, states are the plenary sovereigns, each with their own constitution, while the federal sovereign possesses only the limited supreme authority enumerated in the Constitution. So, know about your enumerated rights, know about your unenumerated rights as well. Indeed, states may grant their citizens border rights than the federal Constitution as long as they do not infringe on any federal constitutional rights. Know what constitutionality is. Thus, most U.S. law, especially the actual living law of contract, tort, property, criminal, and family law, experienced by the majority of citizens on a day-to-day basis, consists primarily of state law, which can and does vary greatly from one state to the next. At both the federal and state levels, with the exception of the state of Louisiana, the law of the United States is largely derived from the common law system of English law, which was enforced at the time of the American Revolutionary War. However, American law has diverged greatly from its English ancestors both in terms of substance and procedure, and has incorporated a number of civil law invocations. Okay. English law. What is this? So, English law, what is this? Because we need to get some clarity on this, because this is actually going to go into a little bit more detail about you changing your status, you changing your jurisdiction, you accepting your nationality. So we have to be clear on exactly who we are portraying in the public, how we are operating, so that there is no confusion as to who we are as a people. So English law is the common law legal system of England and Wales, comprising mainly criminal law and civil law, each branch having its own court. Principal elements of English law. England's most authoritative law is statutory legislation, which comprises acts of Parliament, regulations, and bylaws. In the absence of any statutory law, the common law, with its principle of stare decisis, forms the residual source of law based on judicial decisions, custom, and usage. Common law is made by sitting judges who apply both statutory law and established principles which are derived from the reasoning and early decisions. Equity is the other historic source of judge-made law. Did y'all hear that? Equity is the other historic source of judge-made law. Common law can be amended or repealed by Parliament. Okay, so there is your answer for all of you out there that is saying that we're going to do a common law name change and we're going to go and file our documents in the Court of Chancery. All right, that is not a court of equity, and it can be repealed by Parliament, which means that you are still under the jurisdiction of what? English law. Okay, so you did not change no jurisdiction. Let that be clear. Not being a civil law system, English law has no comprehensive codification. However, most of its criminal law have been codified in its common law origins. In the interest both of certainty and of ease of prosecution for the time being, murder remains a common law crime rather than a statutory offense. That is interesting, my friend. Okay, so then it goes on into a little bit more. Feel free, it's on Wikipedia, to jump on there. Google is your friend. So, Now, I want to get into this because when I said earlier about jurisdiction, it's very important that there is a fine line between who you identify with and are you still up under that jurisdiction. Because I'm going to be honest with you guys, if you are not stepping out of one jurisdiction that is acknowledged and you're not stepping into one that is acknowledged, then you're stateless. And the trust will not fail for the lack of a trustee, which would have been your nation and your tribe. So if you don't have anything to assist you in administrating your estate, if you don't have anything other than common law, acts of parliament, regulations, and statutory law, if you don't have your own set of your own codes, your own law that you follow, and your own judiciary court like a tribal ecclesiastical Beth Din, then you haven't made a transition into anything. And that's where you get this word sovereign citizen, because you have never expatriated, because you didn't have anything to acknowledge your nationality. Who acknowledged you? Even the United States needed to acknowledge Morocco. Otherwise, it wouldn't be there. We'd probably still be in Spain. So, this is important, and this is something that we really need to understand when we're doing our process. Too many of us are one man out, and you're just nothing but something that's kidnapped because you have nobody that's going to stand up and say anything on your behalf. That's important. We have to deal in numbers now, but I'm not going to go off into spilling my heart on that right now. We're going to get into these documents so that you guys can get where you need to go. The private and security agreement. Now, there is a private agreement and there's a security agreement. In my version, I put them both together and made it a private security agreement. Okay? Non-negotiable private security agreement between two parties. Private security agreement dash your recording number dash initials. Okay. This non-negotiable and non-transferable private and security agreement supplements and controls upon and entered into this day of, by and between debtor's name, hereinafter debtor, social security account number, that would be the social with dashes, birth number, birth file number, registered where your birth certificate was registered, and then the secure party's name hereinafter the secure party creditor. Identification would be the 98 number, no dashes. The party acknowledges they agree to be bound by the terms of this commercial security agreement and are identified as follows. So then you have the parties there, the debtor's name. Okay, so there you have the parties there, the debtor's name and address, any and all derivatives and variations in the spelling of said name, social security account number with dashes. Then you have the, this will say secure party's name, but my apologies. Secure party's name, private American natural, neutral party, non-domestic, then your 98 number there, okay? Now, because this document is so lengthy, I'm going to go through a few of them, but we're not going to sit here and read the whole document because I want to get to the commercial security agreement and the hold harmless indemnity agreement. Because sitting here reading all this, shoot, I'd click off this channel myself. So what I'm going to do is I'm going to point out the important parts of the document. If you want to get the document or any other templates, make sure that you email lamu.amexem.foundation@gmail. It's also in the thumbnail at the beginning of the video and ourlamu.org. Now, therefore, the parties agree is the following. In consideration for the secure party involving certain indemnification to debtor, including but not limited to secured party. 1. The secure party creditor constituting the source, origin, substance, living, breathing, flesh and blood, sentient being, basis of pre-existing claim for which the existence of debtor was derived and on the basis of which debtor is able to function as a transmitting utility, granting the secure party the capacity for interacting, contracting, and exchanging goods and services to conduct commercial activity as a conduit for the transmitting goods, services, contracts, obligations, and liabilities with other debtors, corporations, and artificial juristic persons in commerce. That would be the public people. That would be them citizens. So there's a layer of indemnification that one would need because you're crossing over a jurisdiction. A lot of us have not conceived that notion on how to operate in public, because remember, private and public do not mix, okay? Constituting the source of debtor's assets via the sentient existence, exercise of faculties, and the labor of the secured party, which provides valuable consideration sufficient for supporting any contract whatsoever that the debtor may execute and concerning which debtor may be regarded as bound, and providing the security for repayment of all sums and as might become due in owing by debtor. Debtor for value does hereby and herewith agree in covenant the debtor shall undertake the obligation of functioning and serving as a transmitting utility for the benefit of the secured party creditor, granting the secured party ability for engaging in commerce with other juristic persons, indemnifying, defending, and holding the secured party creditor harmless from. Okay, so as you see, this is a lengthy document. Like I was saying, it's 13 pages. Make sure also that we are titling our document. So, private security agreement dash, you put your birthday, whatever series of numbers you want to put. It's completely arbitrary. Dash your initials would be fine, okay? Harmless from and against any and all liability, claims, demands, orders, summons, warrants, judgments, damages, costs, losses, liens, levies, dispositions, lawsuits, legal actions, penalties, fines, interest, and expenses whatsoever, both absolute and contingent. Due and must become due, now existing here and after, arising howsoever evident suffering incurred by and imposed on debtor, and for whatever reasons, purpose, and causes whatsoever. Debtor for value consideration does also hereby and herewith expressly acknowledge, consent, and agree that controlling creditor or entitlement holder or secured party cannot and must not under any circumstance nor in any manner whatsoever be deemed an accommodation party nor surety for debtor. This is a continuing private agreement and perpetuates in effect until death, i.e. the permanent cessation of all vital functions and faculties of creditor. All right, then it goes into the date that this was agreed upon, then the two signatures here, and then it continues into the security agreement itself. Now, the security agreement is going to list the collateral and the assets from the debtor to the creditor, okay? So it's going to list a various things. So, you know you have a UCC, put your UCC number. So I'm going to vaguely go over some of this because I'm pretty sure this document is relatively easy to find. You know, Google is your friend. It's relatively easy to find. My thing is that I just want all of you to understand how to use it and enforce it the right way so that you are getting equitable remedy in commerce if you're going to be entering into any public juristic venues. It goes down into for value consideration, secure party debtor, debtor's name. This security agreement secures, okay? So then it's going to go through everything that the debtor is conveying over to the secure party on behalf of discharging debts or operating in commerce, negotiable instruments, security agreements, as we said earlier, and UCCs. So now you're starting to see that this document is very important when you're going into the UCCs, okay? The collateral you can alternate it. Some people like to put the collateral that they actually used in their UCC. Others can, it's standard. It's up to you. Be creative. You're an author. Create how you want to create. Just stick to the principles, okay? Perfection. Stick to the principles. So one, and then it goes down from paragraph B. This is where I want to be, okay? So let's make sure that we're putting our debtor's name, that we're putting in our birth certificates, our socials, our EINs. Let's make sure that if we have any accounts, that we're putting any accounts. If you have any court cases, you're putting your court cases. You got a name change, you're putting that because you accepted, you did an acknowledgement of acceptance of name change, right? So that's your property. Whoever makes the contract owns the contract. You got any children, you got any decedents, like ancestors, you got any ancestors you need to put on here, do your thing, okay? And it goes down into property, checking savings accounts, 401ks if you have it. If you have any artillery, you put it here. If you have any boats, yachts, everything. Even down to, your fingerprints, footprints, palm prints, thumbprints, RNA, DNA, all of that, all the way into your intellectual properties too. So this document covers a lot. If you got utility accounts, put your utility accounts on there. You got state identification cards, put it on there. If you got weapons license, if you got fisher's license, anything that has an account number on it is a contract, and it came from a security agreement. So let's make sure that we're putting that on there, okay? Now, the private security agreement remains private, okay? Because this is private. You do not need to put this on the record. We went through the means of legitimizing this document when we were reading off of Wikipedia and Investopedia about how do you, with the authentications and whatnot, okay? So it has to be a written contract, and it has to be signed by both parties. That right there legitimizes it. That right there legitimizes a trust indenture, okay? So when you get to that point, I ain't gonna say that to you right now, because some of y'all would really go and take that to heart and be all common law and stuff, and we already had that conversation, okay? But when it comes to tribal things, unincorporated is the way to go, but not for your living. You need to be on the record that you are alive, okay? So then it goes through a series of the rest of your assets. Anything that you could possibly think of is a very detailed document, okay? And then held harmless and indemnified. So we're going to get to the held harmless and indemnity agreements too. So we'll go over that, but it covers a lot of different stuff. I'm not reading all this because, boy, we'd be here forever. But it is something that, you know, if you can go and find one on your own. If you can't, email the foundation. We'll make sure that you get the templates that you need or any other advice that you need. But this is pretty much how this goes, okay? Now, when I did my private security agreement, I did it on bond paper. Anything, just a footnote, anything that's going to the Treasury, it needs to be on bond paper. But make sure that, print the first page first, make sure the format is right, because you'll be going through boxes of bond paper. Okay, so that's pretty much this agreement here. Now let's zoom over to the commercial security agreement, because you see that this document is 13 pages. We're basically at the end of it. It has a constructive notice, just as we were reading about too. So that's there. Now let's go over to the commercial security agreement. Alright, so this, as I said earlier, is an abstraction of the private security agreement. So it's pretty much going to be, this one here is 6 pages, and this is the one I recommend that you put on as an attachment to your UCC. Anytime that you open any entity, it needs to have its own security agreement, its own commercial security agreement. This commercial security agreement would go with you to the bank to open accounts. This security agreement, commercial security agreement, goes anywhere in the public. So this commercial security agreement is what you would put on the record. Just for example, if you are creating a declaration of trust or a deed declaration of trust, right? That would remain in the private. What you would record on the record would be the certification of trust. So if you have an understanding of how that realm operates, then this is exactly what I'm saying as far as the private security versus the commercial. Because now we're entering into the public, into juristic territories. So let's be mindful of that. It goes into the same situation. It lists everything, the abilities, the contract, the reasoning for why the debtor is giving the secure party, the agreement, the conditions, the provisions, everything, the collateral to an extent. But it is redacted on, your personal information unless you want it on there. It's redacted from your birth certificate number, your social security number, and everything that is vital. Vital information has been redacted, okay? And if they want to figure that part out, then they need to ask permission. If they want you to identify your person to that fashion, then they need to ask you in written form for permission to do so and have the basis to get that granted. Otherwise, why? Mind your business, okay? So these two go together, and it also goes with that UCC1 regional filing, okay? So, and it goes through all the derivatives and everything, and also with that common law copyright, because hey, why not do a common law copyright if you're gonna file it in the parliament anyway? So that's the way that they would do it. But I take it a step further and actually do a newspaper publishing of a copyright and trademark, and take it on the federal level, because a lot of people don't really get that part either, is that just because you copyright or trademark things pertaining to yourself, and see, a lot of people don't understand that when you do trademarks and copyrights in the state, it's only good for that state. So you need to boost it up to the federal status of that, so that it is all over the states, because I guarantee you, you got creditors that you did a security agreement with in your domicile state, but they are headquartered in a whole nother state. So that went out the window right then and there. So that's something to think about. Okay, so let's jump over to this hold harmless and indemnity agreement. Okay, another thing that I forgot to mention in the last video, that registered mail number. So that's going to be in the next video. Notice of claim, notice of transfer of that registered mail number. So we're going to go over that in the next video. And since this video is already at almost 40 minutes, I don't want to make it too long. So I'm going to go ahead and do the common law copyright and the notice of claim, notice of transfer, and the rest of this tier 1 unit, and knock it out in that video, okay? Alright, so this non-negotiable and non-transferable hold harmless and indemnity agreement is mutually agreed upon and entered into this day by and between John Henry Doe, hereinafter debtor, social security account number with the dashes, for the creditor, birth number with the birth number. Okay, registered in where yours is registered now. Make sure that you look at your actual birth certificate. Hold harmless and indemnity agreement. Non-negotiable private hold harmless and indemnity agreement between the parties. This non-negotiable and non-transferable hold harmless and indemnity agreement is mutually agreed upon and entered in on this day between John Henry Doe, hereinafter debtor, social security account number with the dashes, for the creditor John Henry Israel, birth number, birth certificate number, registered in the Minnesota Office of Vital Records. Now, let's make sure that we're actually pulling that birth certificate out and making sure that we're identifying our proper agency correctly. Some of us are not Vital Records. Some of us are Department of Health. That's important. And John-Henry Israel, here and after the secure party. Creditor identification number. Now, you could put your social without dashes, the social without dashes, and if you would like to, if you've already obtained it, you can put your 9A number there, depending on how you're doing your process, because there's different ways. Some people do not annex into a title like I did. Some people just do proper syntax, but either way it goes, you're supposed to have a 9A number. The social without the dashes, and I left it this way because I wanted to talk about this. The social without the dashes, beloved, belongs to the debtor. The creditor itself steps out in the 9A number. Even though it did a status correction with that administrative office, it still has not circulated that number. It circulates the 9A number. Back to the security agreement, back to the UCC1, back to trade lines, back to being a creditor, okay? The parties acknowledge they agree to be bound by the terms of this hold harmless and indemnity agreement and are identified as below. So then it goes through the same identification as the private security agreement and the commercial security agreement, okay? Held harmless and indemnified. This hold harmless and indemnity agreement is mutually agreed upon this date between the debtor and the secure party. For value consideration, debtor without benefits of discussion and without division does expressly hereby agree, covenant, and undertake the indemnification of, and does not hold harmless creditor from and against any and all claims, legal actions, orders, warrants, judgments, demands, liabilities, losses, dispositions, summonses, lawsuits, costs, fines, levies, penalties, damages, interest, and expenses whatsoever, both absolute and contingent, as are due and as might become due, now existing as might hereafter arise, and as might be suffered by, incurred by, and imposed on debtor for any reason, purpose, and cause whatsoever. Debtor hereby and herewith expressly covenants and agree that creditors shall not under any circumstance nor in any manner whatsoever be considered an accommodation party nor surety or a debtor. And then it goes through some words, define glossary terms. As used in this hold harmless and indemnity agreement, the following words and terms express the meaning set forth as follows. Non-absentee. Conduit. In this hold harmless indemnity agreement, the term conduit specifies a means of transmitting and distributing energy and the effects produce of labor, such as goods and services, via the name John Henry Doe, John Henry Doe L, and any and all derivatives of the spelling of the debtor's name. Now, let me pause right here. I'm going to pause right here for a quick second, because this is where we get into the understanding of having an actual court order name change and why it's important. Because I see a lot of secure party creditors become secure party debtors, and it's sad. I see a lot of people going and they say they're doing these common law name changes and they're trying to discharge debt. Your secure party doesn't even end up being an illegist. It's a juristic person itself. It's nothing but an AKA a DBA. That's why you do a court order name change. Because when you do a court order name change, that estate name is no longer in existence. You killed it. In the eyes of the law, they cannot even send you a mail in that name because that person, it does not exist. It's corporately dissolved. And now you go into your new name. And now when you're in this new name, you have to understand how to operate, because you can go and be a secure debtor all over again. Then you got to do a whole new name change, beloved. You don't want to do these things. Okay. Now, while I'm on this topic, let's talk about these DBAs that people are out here doing, which is insanity. So you're going to tell me, instead of doing a court order name change to dissolve the corporation and move inside of the private trust, that now you're going to go and change your jurisdiction by asking the secretary of that state to let you use a fictitious name change, which is a juristic person, to get an 82 number, which is a sole proprietor, which is the lowest of entities that you can get, also that you and your debtor can be in a contract with the state. Come on, think about that. That is irrational. So, back to this document. Debtor in this hold harmless and indemnity agreement, the term debtor means John Henry Doe, copyright registered trademark, John Henry Doe L, copyright registered trademark. Derivative in this hold harmless indemnity agreement, the word derivative means coming from another, taken from something preceding, secondary, that which has not the origin of itself, but obtains existence from something foregoing in or a more primal and fundamental nature, anything derived from another. Illegist. In this hold harmless indemnity agreement, the term illegist means a creature of the law, an artificial being, as contrast with a natural person such as a corporation considered as deriving its existence entirely from the law. Hold harmless and indemnity agreement as used herein. The term hold harmless and indemnity agreement means this hold harmless and indemnity agreement number. Now this is where you would do your identification. So what is the document? So this is a HHIA, hold harmless indemnity agreement. Whatever numbers you're using to record, birth date, serial number, whatever, you put that there with your initials. As this hold harmless and indemnity agreement may be amended and modified in accordance with the agreement of the parties signing hereunder. Together with all attachments, exhibits, documents, endorsements, and schedules, this hold harmless and indemnity agreement attached hereto. And then it goes into juristic person, living sentient flesh and blood woman or man for you, and the rest of these documents. So I want to carry on into something else, but this is part of the things that would be filed too. So let's keep that so we know that if we filed our UCC1 regional, then our attachment is our commercial security agreement, then don't you think that we need to hold this secure party indemnified? Don't you think we need to hold them harmless and indemnify this creditor too? So let's do that and put those together, and then you go and you do your UCC3. Do not do your UCC3 if you have not done the UCC1 regional, international, and non-UCC. If you have not done your non-UCC, your UCC1 regional, and your UCCC and your UCC1 international, do not do your UCC3 for that regional filing until you have a certified copy that with these documents attached to that regional UCC1, until you have a certified copy of that filing, you do not need to be doing a UCC3 because you're jumping the gun. Okay, you're automatically jumping into commerce with bonds and you ain't even indemnified yourself or put on the record that you indemnified yourself. Take yourself and put it on the record. Let's make certain that we are crossing our I's and dotting our T's, because it's a sad case. Every time I turn around, I'm seeing people have so much fragmented information that, you know, they're just so confused and don't know how to even operate. Nobody is teaching people how to operate in this lifestyle. This is a lifestyle, beloved. You know, and so now I'm going to sit here and I'm going to do these videos to make sure that you know the sequence of information so that you can get to this other side. I see you at the powwow. We can hang out. We can build. We can do all these things. But you got to be in perfected status. And you got to be in your natural state. And you got to be uninhibited to a point. Operating in commerce is fun, but it should not have to be a necessity. You are the money. You the bag. Let's remember that. You the bag. But you need to be credible at the same time. So I'm going to close out this video here, and I'm going to move on to my next section so that we can get to our live Q&A for Wednesday, and I'm going to holler at you guys later. Greetings. Shalom. Have a beautiful day.